Welcome to For the Record with Greenwood Law.
Welcome to For the Record with Greenwood Law and attorney Dylan W. Greenwood, founder of Greenwood Law in Winston-Salem, North Carolina. Dylan is a criminal defense attorney representing clients in both state and federal court, known for his high-level, personalized representation and hands-on approach to every case. I'm Leann, and today we're talking about search and seizure, one of the most important parts of any criminal case and one of the areas people misunderstand the most as well. Hello, Dylan.
Hello there, Leann.
Dylan, nearly every criminal case touches search and seizure in some way. When you're evaluating a new case, what are the first things you look for in terms of how the stop or search began?
Sure, and that really is where almost every single criminal case begins. How does the person that I'm representing come into contact with law enforcement? Sometimes, rarely, somebody does not know that they're being investigated and everything was being done in different ways, and then all of a sudden they're having contact with law enforcement. A lot of times, though, there are situations where either a search warrant is being served on them, usually in relation to like a house, an apartment, something like that, or when you have a situation where somebody is pulled over in a car and there's a series of events where it might lead law enforcement to then be able to search that car or someone's person, depending upon what happens in the stop.
Well, as you just mentioned, traffic stops lead to many of the searches you see in court. Under North Carolina law, what allows an officer to expand a simple stop into a full-blown search of a vehicle?
Sure, there are a number of different things. And what people need to understand is that relative to where you reside, a home, an apartment, you have what we believe and our jurisprudence puts out that you have a reduced expectation of privacy when it comes to your automobile or car, SUV, whatever. And the things that can lead ultimately to law enforcement being able to search in those automobiles, uh, first and foremost, plain view. If there's something that is illicit or should not be there that is in plain view, it can cause a police officer, law enforcement official to search. Other things are if there's enough probable cause on the scene where you don't have to have a warrant, but you have probable cause where something can be searched. Now, typically that's supposed to be probable cause plus some sort of exigent circumstance. Typically, exigent circumstances have to do with preservation of evidence, law enforcement safety, public safety concerns, things like that. There are all different forms of exigency which create the need to forego a warrant and just search on the side of the road. The most common of which with a automobile is honestly the smell of marijuana or what is suspected to be marijuana. And that oftentimes has been recognized that that smell alone can be enough to warrant for a search of an automobile. And frankly, that's how we see most of them occur.
Consent searches create a lot of confusion. What should people understand about what it means to consent and how courts determine whether that consent was truly voluntary?
So that's probably one of the more frustrating parts of my job is that you're talking to somebody and you're kind of going through everything, and in your head, you're going, okay, this might be something worth challenging. And then all of a sudden they go, well, I just let them search. I told them it was okay because I felt like, it was going to go better for me if I did that. Well, not necessarily, no. And again, that's a frustrating part of my job because let's say otherwise, let's say if a police officer just decided that they were going to search your car and they didn't have all of the necessary Fourth Amendment check marks ticked, and they know that, or maybe they don't know that, and they just ask you then, hey, do you have a problem with us searching? So many times it happens. And once that person says yes, it's okay at that point. You've consented. And that's, again, you've taken away all those potential challenges that I might have, or the ways in which I might be able to use leverage to figure a case out. Now, if that consent has been coerced in some way, either there's been a form of duress or it was done in an interrogation like fashion where somebody wasn't given their Miranda rights, or even when it wasn't that formal, but it was still like some sort of coercion, that may have been an invalid form of consent. Those don't happen as much. That's honestly a rarity from what I see. But more often than not, I see the law enforcement official that doesn't necessarily have everything checked, and then they just see if you'll consent, and so many times someone does.
So, what's a better answer than yes? No?
I think more often than not, people when they interact with law enforcement want to be respectful. Okay, it's a nerve-wracking interaction. Most of the time, a law enforcement official has a gun on their hip. There's the badge. There's the appearance of authority. A lot of times they're standing over you, literally. So, literally a physical position of dominance. And I think that a better course of action, especially like I said, I think most people want to be respectful, is to say, you know what, Mr. and Mrs. such and such, yeah, I respect the job that you're doing. But at the same time, I would like to exercise my constitutional rights. And at this time, I don't consent to any searches of my person or my automobile. And just say, you know what, I appreciate what you're trying to do. Hope you stay safe, whatever it may be, but I'm not going to consent at this time. That's a little bit better than just a flat out no, you're not searching. And, that's going to be a little bit more abrupt, maybe perceived as less respectful. So I think there's a way to maintain the level of respect and decorum, but also asserting your constitutional rights. And I don't think there's anything wrong with that.
I appreciate that. Well, we know phones are the center of so many of investigations now. What does the law require before officers can search someone's cell phone or digital data?
First and foremost, the biggest recommendation, always password protect your phone. Some people use Face ID. That can be okay. But it is possible for somebody to just hold your phone up to your face and all of a sudden it's unlocked. So passcodes offer that much more expectation of privacy. If you don't have that, then I think a lot of courts, a lot of judges would look at that as you don't have an expectation of privacy on your phone. You haven't protected it in some way. But otherwise, probable cause needs to be present for someone to search immediately, like on the side of a road or like as soon as they come across the phone. They would need some sort of exigent circumstance, like they believe that the phone might be erased in some way, or that the data might be deleted, whatever it may be. More often than not, what I see with cell phone searches are that they get seized, and then a warrant is then procured, and then that warrant allows for the searching of certain necessary things. That is probably the preferred method from law enforcement that takes away from the possibility that someone like me might bring up a motion to suppress.
Can you describe a moment in a past case where a search that seemed routine at first turned out to be legally flawed once you examined the details more closely?
Sure. Had a case one time where officers initially went to a house for what was a safety call, like a safety check. They went beyond that, and they actually went into my client's back shed and found stuff back there. And then the officers did not realize that they were on surveillance cameras at my client's home. And you can see them having a bit of a meeting about what to do, and they run off and go get a warrant, and then they come back and they try to say that it was justified later because they got this warrant after the fact. Not realizing that someone could prove that they actually went in and found the stuff unlawfully beyond the scope of some sort of safety concern in this back shed away from the house almost an hour prior. And when I brought that up and brought up the how I did not believe that that was legal, all of a sudden there was a significantly reduced different outcome in that case where that individual they had to do some things, but it eventually was able to be dismissed, actually.
Okay. Search warrants often look straightforward to the untrained eye, but you reviewed hundreds of them. What parts of a warrant or the application behind it tends to raise the most concern during a defense review?
They're always interesting because when a law enforcement official applies for a search warrant, they're signing an affidavit and they're signing something that is essentially testimonial under oath that, to their knowledge is something truthful. I've seen that backfire before when information maybe was not correct in the warrant that could have easily been verified. So that's one thing that we look towards, like what information are they actually relying upon to support the probable cause necessary for the search warrant to be issued. You also look at the qualifications that are listed by an officer or detective. So a lot of times a search warrant starts out with just this almost like a resume, a CV of everything this officer's done, and what their training experience is and why they're trying to apply for this warrant, and then all of the investigative aspects up to that point. And you're trying to break down whether or not that's lawful, whether or not the information was reliable, whether or not they could have figured out the reliability of the information through other means. And frankly, when it comes to a state case, you're looking to see who signed off on it. Was it a magistrate judge? Was it a superior court judge? Who did they get the signature from? I think is a detail that matters in certain cases, and overall, all of that goes into the analysis of whether or not that's something to try to attack, or whether or not you feel like it can be relied upon in some way.
Federal investigations operate under different rules and resources. When a case involves federal agents, what tends to change about how searches are carried out and documented?
Some ways it's different, some ways it's not. There's still the level of probable cause that law enforcement has to reach to justify the search or the warrant. I think people need to really understand is that the federal government has the most thorough and well-funded investigation force anywhere in the world. Between the FBI, the DEA, Homeland Security, just name all the different acronyms. And I mean, they're all at, their disposal. And the way that a federal investigation occurs, you have an assistant U.S. attorney that is more directly involved with the investigation, providing direct legal counsel on it, and usually providing their insight as to whether or not someone has met certain thresholds to apply for, warrants or what have you. There's the ability to apply for wiretapping, which also occurs at state court level as well, but you see it more often in federal, especially federal drug investigations. Stuff called like pen registry warrants is a very unique type of a warrant that you see that's filed in federal court that is allowed through certain aspects of the law, actually really old parts of the law that have been applied to modern things that we have. All of that is there, but the big difference with how a federal investigation is conducted relative to a state one is the federal grand jury process and the ability to bring in witnesses before a federal grand jury and to use that as a part of the investigative scheme to further an investigation along and to lay the groundwork to get some of the warrants and things that you might need in a federal investigation overall.
Many people assume that if something was found, the search must have been legal. Why is the legality of the search itself so separate from whatever evidence was discovered?
Sure, that's because it's what's called the fruit of the poisonous tree. I mean, that's literally like how it is talked about in our jurisprudence. And if something was found, but it was done so illegally, then it's it should be suppressed, and that's what happens. You file what's called a motion to suppress to analyze the legality of the search that was done. And what you're saying is that this person has a constitutional right. They have a constitutional right against unreasonable search and seizure. There is some aspect of the way this occurred that violated that constitutional right. Therefore, it's suppressed. It's locked away. It can't be used. And if that's locked away and it can't be used, then everything that comes off of that is poisoned, basically, and it can't be used. So a lot of times, if the stop was found to be unconstitutional, the seizure of somebody was found to be unconstitutional, the search was unconstitutional, a lot of times that's going to nip the analysis right there. And a lot of times something can't proceed in the case from that point forward because everything else was unconstitutional or based off of something that happened that was unconstitutional.
As we wrap up today's episode, when a search becomes the central issue of a case, how does the challenge typically move through the court system? And what kind of outcomes can that motion lead to long before the trial ever happens?
That's an excellent question. And it depends in state court, it depends on whether it's a district court or a superior court. District court, any of it, you file a motion and you lay out your reasonings for why you think the evidence should be suppressed. When that happens in district court, it typically just occurs before the trial, at whatever the trial date is. Superior court, it might be scheduled during like a motions calendar. It could be called and tried before the actual jury trial, but they tend to try and figure those issues out before you ever call a jury in, because a lot of times those types of motions can be what's called dispositive, which means that if the defense, for instance, is successful on it, then likely the case will not be able to proceed. So it all happens, and it's a judge trying to determine the legality of what occurred. In federal court, it's a little bit different. You have all these guidelines for calendaring when the motions have to be filed, by what time, and then they get put on like a certain docket to where they get heard. You try to forecast how much time you think you're going to need. And in any case, whether it's state or federal, you got witnesses that are called, arguments that could be made, and then ultimately a judge decides on it. Not every potential suppression issue, however, goes to a hearing. A lot do, but not everyone does. And sometimes bringing up, and I alluded to this in the example that I made before, sometimes bringing up the issues is enough to push the ball forward on a potential outcome or disposition in a case that either someone can live with or provides them an opportunity to better themselves, maybe through like a conditional discharge agreement where if they do everything, it gets dismissed. Whereas that might not have been on the table before, but because of the potential suppression issues, all of a sudden you've got a prosecutor that's on board with it, or maybe wants that to happen. There's different ways that it can be used. Every case is different, so it's about kind of, being able to take the temperature of the room and figuring out, what's going on and how you can use it. But when you have that issue in your back pocket, it's just another tool in your tool belt.
Well, that is it for today's episode of For the Record with Greenwood Law. If you'd like to learn more about attorney Dylan Greenwood and his work at Greenwood Law, visit dwg-law.com. You'll find helpful resources about criminal defense in North Carolina, from state charges to federal cases. Thanks for listening, and remember to leave a review, and share this episode with someone who might need it. Thank you, Dylan.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.